Walter Rove, you're all very welcome this afternoon to our webinar, Consumer Protections for OMCs, Insights from the Property Services Regulatory Authority. Tású agam go manishiv sult asan glár inniu. David Rouse is my name, Multi-Unit Developments Advisor with the Housing Agency. We have almost 200 people registered for today's session, and as they are logging in, we will give them a chance to join the session. And while they're doing that, this is our timetable for today. We'll have a little introduction and we'll run a poll to see who our audience members are. We'll then give you a short update on news in the mud sector. At about 20 to 1, Maeve Hogan, CEO of the PSRA, will kindly give her presentation. We'll have time for questions received by email. Thank you very much to those who emailed in. We have about 10 questions, which we hope to get through in good order after Maeve's presentation, and we'll wrap it up no later than 1:30 p.m. So as people still are joining us, a little bit of housekeeping. The chat function is available if you have problems with sound or vision. My colleague Emma Whelan is available in the background, just monitoring things. Thanks very much to Emma for her support on that. As I mentioned, we have questions received by email. We will put them on screen and we'll deal with them after Maeve's presentation. Please feel free to relax and, if you like, sit back if you now have a nice cup of coffee or your lunch with you, and watch the slides and watch the presentations. We'll email it all out to you either later today or tomorrow, so don't worry about that. You'll have the slides after the session. The webinar is being recorded for future use, so it'll be on the Housing Agency's YouTube channel in short order before the end of the week. We should enter the important information that what we're covering today is general guidance for you in your work with OMCs, MUDs. You might be an OMC director, etc. It's not legal advice. We can only give you signposts and directions. Legal advice is required in relation to individual circumstances. So, and I know Maeve will be mentioning that point as well. So I'll stop sharing briefly and we will run our audience survey just to see who you are. So you might kindly respond to this as best you can. It is anonymous, so feel free to answer. There will be no connection between your answer and your contact details or email address or whatever else. So are you an OMC director? Are you a licensed property management agent? Are you a member of the staff of a local authority, city or county council? Are you with an AHB, an approved housing body? Maybe you are an owner of a home in a mud. Are you a tenant, a renter? Are you an investor, landlord? Are you in the legal sector? You might be a solicitor. Or are you in the construction sector? You might be a developer or an architect or an engineer. Or finally, you might be in the finance accounting sector. So please feel free, as I say, to respond to that. It gives us a better sense of who we're talking to today. And I'll run that for another little second. Thank you very much. Nearly 80% of you have participated. So the more that participate, the better informed we are. And as I say, it is anonymous. There's no link between your reply and your contact details. So if we could maybe get a couple more answers, we'll get it to over 80% of those logged in, and that would be fantastic. So I'll stop sharing that and I'll stop running the poll, and I'll share the results. So nearly 30% of you are directors of an OMC, 23% are property management agents, 7% from the local authority staff sector, nearly 10% from AHBs, 13% owner-occupiers, investors, landlords, 2%, 3% solicitor, legal sector, and 7% in construction and in accounting and finance. So thank you very much for responding to the poll. I'll share back my slides again just to run through some of the last pieces of housekeeping. As I say, we will send out the slides and we're recording this for future use on our YouTube channel. A little bit about the housing agency. Those of you maybe you haven't encountered us before, we work with local authorities, AHBs, stakeholders, professional bodies, our parent department, the Department of Housing, Local Government and Heritage, in relation to the housing sector. We are a centre of housing knowledge. We support the creation of sustainable and inclusive communities, and we address housing supply and affordability. You can find out more on our website, housingagency.ie. This is the team in the agency and our offices on off Merrion Square on Mount Street Upper. The mud section, this is what we endeavour to do to support people working with MUDs, people living in MUDs, OMC directors. Our email address is mud@housingagency.ie. If you haven't done it yet, please subscribe to our newsletter, our new newsletter, MUD Matters. It's available on a periodic basis. It will give you updates on resources, information, training, insights, research. There's the website, there's the web link. Go on and subscribe for it when you can. What's in that? We'll be updating you on our outreach events. We'll be around the country in September and October. The red points, the red pins are where we've been to date over the last 5 or 6 years. The green ones are where we will be in September and October. So Dundalk, Athlone, Ennis, Cork, and 2 sessions in Dublin. So we're trying to cover the country every year, and you can see we've covered a lot of areas around the country. So thank you very much to everyone who's attended those. Other things you'll see in our newsletter are information and guidance from other state bodies. For example, the Corporate Enforcement Authority in recent weeks has issued guidance and an information note on virtual general meetings, how to conduct those, how to operate general meetings, very relevant to OMCs over Teams or Zoom or whatever other platform. The overarching guidance is members, participants should have a reasonable opportunity to be involved and participate in the meeting, but you can read that 6 or 7 pages of guidance in your own time. Our next webinar will be on the 26th of June. It will be in relation to a fantastic new report funded by the Environmental Protection Agency on optimizing food waste segregation in apartments, a really challenging issue for multi-unit developments and apartment blocks. So there'll be more information about that in our next newsletter and on our website. We have produced resources about retrofitting, a very hot topic at the moment. There is a detailed YouTube webinar on training videos and presentations available to cover building life cycles, the SEAI grants, project management, bringing your owners on the journey of retrofitting and upgrading. So I'd encourage you to go onto our YouTube channel, watch that webinar, find out how to access those resources. A quick update on MUD reform, if you want to call it that. The Multi-Unit Developments Act, the primary piece of legislation for the sector, is due to move from the Department of Justice to the Department of Housing under the programme for government. That is awaiting legislative change under a piece of legislation been put through the Oireachtas by the Department of Justice. There's an update there. It was before the Select Committee on Justice only yesterday, so there'll be more updates on that. Coming close to the end of a quick update on a couple of other items. We're trying to create a register of OMCs. To do that, we'd ask you, when you're filing your annual return with the Companies Office, to tick this box highlighted in red to identify the company as an OMC. For reasons that will be obvious, the state needs to have a clear register or a database of OMCs for fire services, for fire safety, for contacting people who don't know about the work we do in due course. So please help us with that if you're an agent, a director, a company secretary. There's guidance on the CRO website. There's guidance on our own website about how to do all of that. So that's our little MUDs update and our intro to the housing agency. What are we here to talk about today? We're here to talk about the relationship that's in the red circle on this diagram of what a multi-unit development is. We're here to talk about the relationship between the owner's management company and the property management agent. And we're delighted to have, again, for I think the third year in a row, proving how popular the session is. We're delighted to have Maeve Hogan, Chief Executive of the Property Services Regulatory Authority, here to discuss these issues, to give us a presentation on regulation, on licensing, and on consumer protections for OMCs. We'll have the Q&A after Maeve's presentation, and Maeve will be joined later by Antoinette Gavin, her colleague in relation to investigations and disputes. So we look forward to hearing from Antoinette after Maeve as well. But I'll stop sharing again, and I'll call on Maeve to turn on her camera, and hopefully, Maeve, you can hear me and we can hear you. And we will ask you to share your slides, and I will hand over to Maeve when she's ready to do that. So hopefully all be well. That's looking good, Maeve. We have your slides, and if you want to put it into presentation mode, it should look ideal.
Thanks very much, David.
Excellent, thank
Good
you.
afternoon. Good afternoon, everybody, and thanks for joining us here today. I propose to give an overview of the PSRA and our role and functions, particularly focusing obviously on OMCs, and delighted to see that there is a large percentage on the webinar today from OMCs and management agents. So hopefully a lot of this will be known to you and maybe reinforce some of the issues that you are dealing with on a day-to-day basis. As David outlined, I don't propose to give anybody legal advice as OMCs. You're your own management company. You should have your own legal advisor. So anything here today is really guidance or matters to assist you in dealing with, your day-to-day issues that you address. David has received many very good questions. So I think we'll dedicate a good bit of time at the end to try and address those questions. I think they're very relevant and very apt in relation to OMCs and the role of PSRA as well. Just very quickly about us, we were established as we have established licensing system with minimum standards. We have code of practice. Our legislation is largely consumer protection based, particularly in relation to client monies, which OMCs deal with quite an amount of fees in relation to running of the OMC itself, and obviously sinking fund. We have established a complaints process in which Antoinette Gavin, who's on the call here, heads up our investigations unit. We have a compensation fund, and that fund is directly related to dishonesty. So where there's dishonesty, the compensation fund can come into play. And we have found and issued grants in relation to dishonesty in relation to OMCs and management agents. So, it's right across. There are very few, I have to say, very few, but the potential is always there, and the compensation fund there is to obviously compensate OMCs in such matters. And our other serious statutory role is to increase public awareness around the role of the PSRA in relation to all aspects of licensing and including the OMC. We were established in 2012. We have our head office is in Navan, County Meath. We also have since we moved our transfer of functions, we moved from the Department of Justice Department to Housing on the 1st of August last year. So we're now based also in Custom House in the Dublin. We operate under a board of 11 members on the board. Number of licensees, we have just over 1,800 businesses, 562 there of those hold a D license. Of the businesses, there's 1,800 businesses. Of each business is required to have licensed employees, so there's over 4,212 there, so over 4,000, of which 1,655 have a D license. In total, we've just over 6,000 licensed between businesses and employees as of today. We have a code of practice, again, management agents to act professionally, honesty, with integrity, act confidentially. A lot of confidential information is held by management agents to be open and effective communication, key aspect in any role that any of us engage with other third parties. Communication can resolve an awful lot of queries and issues, prevent issues developing. And professional development, there is a CPD program for the sector for management agents to complete 5 hours CPD annually. Again, licensing, a key aspect of the statutory role of the PSRA. We have 4 license type. The key one that applies here today is the D license for property management services. So as I outlined, all businesses are required to be licensed, and their employees who deliver the services as management agents and their employees who deliver management agent services are required also to be licensed by the PSRA. Key question we keep being asked about in relation to OMC self-managing, and I think one of the questions related today also is submitted to address this query. There is no obligation in OMC to engage a property management agent. Where an OMC chooses not to appoint a property management agent and instead pays a member of the OMC to self-manage the development, this person does not require a PSRA license to carry out this work. However, any issues that arise where an OMC is self-managed are outside the remit of the PSRA. So the complaints mechanism doesn't apply, the compensation fund mechanism doesn't apply. So just to be aware of that. And that one of the key issues that we get consistently around queries into ourselves is that the PSRA has no remit in running the OMC. You are the OMC, you run the OMC yourselves, and you appoint a management agent to assist you in running the OMC. Both the business and your management agent must be licensed. We issue a credit card size license card to each employee. So it contains the name of their employer, the license type again. D-license type is for provision of management services with an expiry date. The management agent can be asked to produce the license card on a request. And the principal officer and employee can only be licensed for service of which their employer is licensed. So if you're an employee, even a management agent, you must have the D license. Your business, your manager, your employer must have a D license for you to provide the D license. Just a quick view what that license card looks like. It has a picture of the name of the licensed agent, and can see clearly there the property service that this person is providing is a D license, and that's all they're allowed to provide in this case. We do have a publicly facing register of all licensed agents, be they businesses or employees. So for your management agent, if you're employing a management agent, you should go onto our register, which is updated weekly, PSRA.ie, and check the register for licensed agents, and your agent should be there. If they're not there and they're providing a property service, we'd like to know about it, because that will be unlicensed services. One of the key documents in contract documents between yourself, the OMC, and the management agent is the letter of engagement or service contract for services. This is a key document that I can't stress how important this document is. It's a document detailing the services to be provided by the management agent to the OMC. It's certain aspects of the document are compulsory to be included in every letter of engagement. However, if the OMC wants to add additional conditions to the letter of engagement, to the contract, they are welcome to do that, and they should do that if they feel there's a service that they want their management agent to deliver. This document is critical when we get a complaint. It's the first document we look for. See what was agreed between the both parties. The document should be signed and dated by both parties. So the licensed agent, the management agent signs it, as does the directors in the OMC. So it's a key document detailing all the types of services, charges, fees, that's to transpire between the two parties over the coming 3 years. Possibly 3 years is the max that a letter of engagement for a management agent and an OMC can be signed. Just a few pointers. The PSRA strongly recommends that a new LOE is issued or an existing LOE is amended when new directors are appointed. So it's important that one of the aspects we ask you to complete on the letter of engagement is to identify the directors who will engage with the PSRA in the event of a complaint is received. So if those directors change, or if anything that impacts the letter of engagement, consider either amending the LOE or creating a brand new letter of engagement or new contract. An OMC can request that non-mandatory clauses of an LOE be changed, amended to better meet their needs. That's a key. Again, I restate that. If there's some needs or some issues that you want included or amended in your LOE, you're welcome to do that, and we are strongly advised to do that. Where both parties fail to come to an agreement on disputed clauses, do not sign the LOE. It is a contract. It is a binding contract between both parties. Suggest, if necessary, consult your legal advisor or mediate out the issue. Always ensure that property management services being provided are clearly outlined in the LOE and that there is a valid LOE in place. It should go without saying, but we do come across some OMCs that don't have a valid LOE in place. Just a few pointers around that letter of engagement. The contact details for the persons authorised to instruct the agent. So who on the OMC is appointing the management agent? Property services to be provided. These should be clearly identified in the LOE. The list of services to be provided by the management agent to the OMC, and it's important that they are listed because these are the services that, if there's any disagreement or dispute, this is where we go to see what was agreed between the both parties to be provided. Important is to consider prior to engaging property management agent, and I know the housing agency have a very detailed document on this. What services will be provided directly by the property management agent and what services will be procured on behalf of the OMC by the property management agent? Has the OMC granted the property manager delegation to enter into contracts on their behalf? Or are the directors in the OMC going to do it themselves? Now, I would imagine most OMCs do delegate to their management agent to enter into contracts on their behalf. And if that happens, what oversight arrangements are in place in relation to engaging with the management agent concerning these contracts? Have the property management agent's fees and commissions been clearly set out? Is there a provision for a review of fees, of charges? This is one of the areas that we do get a lot of complaints around: management fees and revision of fees. So be very clear that the contract sets out the fees and commissions to be paid to the management agent, and if there is to be an increase or if the review of these fees, how that is to happen. Again, should be recorded in writing in the contract. A very important aspect of the contract is who has access to the relevant OMC bank account. Does the bank account require more than one signature? Does the management agent have sole access to the relevant OMC bank account, or is there a requirement there for a director to sign off in relation to that as well? Good practice would be that the management agent and one director or even two directors would be signing off. We're aware that management agents do have full access to the client account and write checks without requirement of a director of a signature of a director. Again, if that is the case, strongly advise OMCs to have good oversight in relation to how their accounts are managed. Have former directors and our property management agent employees been removed from the bank mandate? And how is this confirmed? So there's names of people who are mandated to write checks or transfer monies out of the account if they leave the company, if directors leave the OMC itself as a director, or if the management agent changes, to ensure that the bank mandate is also changed to reflect those changes. What if any decisions, payments can be made by the property management agent without prior consultation with the OMC? Again, if you're giving full access to a management agent to access your accounts, what oversight has the OMC in relation to that? Has the property manager taken out and paid for appropriate insurance cover for the OMC, and how would you know? We've had to deal with some serious issues relating to insurance of OMCs. Insurance not in place and the OMC believing that the insurance was in place. As an OMC, we strongly urged you to ensure that there is proper insurance cover in place on an annual basis and to check out the policy that it is valid and in place. It's one of the more serious things. If anything from a health and safety perspective happened, you will be relying on your insurance. So it's a bit late to be finding out when an accident happens that there isn't proper insurance in place. So as an OMC, we would strongly urge that you ensure and assure yourself that there is proper insurance in place. And we deal with the case study in relation to that later. The housing agent has published guidance for OMCs on engaging a property management agent, so we strongly advise that you review that if you are considering changing and appointing a new agent. The client account, another aspect in relation to the letter of engagement. Who has access to your client account? Where is all the money? Is the relevant people mandated on it? Are all the monies going into a relevant bank account, as in, are they all the monies going directly into an OMC account, or are they going directly into a management agent's account to be transferred across to the relevant OMC account? Again, all that should be ironed out well in advance, and good oversight there by the OMCs to ensure that those monies are transferred as per the agreement. The PSRA Consumer Protection Complaint Process and Compensation Fund. Just quickly about complaints. The complaints we get from the OMCs generally tend to be around poor service provision. Has the OMC engaged with property management agents regarding poor service provision in the first instance and prior to making a complaint to the PSRA? What we're finding is people are coming directly to the PSRA complaining that, leaks aren't fixed, or the car park isn't, access gates are an issue with. What we're saying is that where there is a complaint, the first instance should be to the management agent or the OMC rather than coming directly to the PSRA, because we're writing back to the OMC or we're writing back to the management agent to try and get details in relation to it. So we advise that the first protocol should be directly to the OMC or directly to the management agent. The first thing when we get a serious complaint is we're looking for the letter of engagement, and we do find that there are no letters of engagement in place. You are required as an OMC and management agent to put in place a valid LOE. You are required under the MUD Act to have renew that LOE or contract every 3 years. You must nominate directors to engage with a property management agent. It's only fair. Some OMCs have, between 3, 4, 5, 6, 7, 8 members as directors on OMC. The management agent can't be expected to be responding and liaising with 8 people. So you should nominate a person or 2 persons for which the management agent can go directly to engage with the directors. Any amendments to your LOE, we recommend that a new LOE is put in place, or certainly the old one is amended and signed off by both parties. Document all services provided by the management agent, and there should be no assumptions. Oh, I thought the management agent would do this, or I assumed the management agent would do this. This is a contract between the 2 parties, so the full details should be put down in writing. If somebody is providing a property service while unlicensed, we'd like to know about it, because they're operating in a regulated sector and they're not in compliance with the regulations. We get a lot of complaints around fees and outlays, so be clear about the fees and outlays that are being charged by the management agent, and that if they're to be increased, that there is provision to do so. Client account breaches, we get complaints around that, and we look into that ourselves. Anything to do with money is a red flag from our perspective, and something that we do take seriously. So we do have active engagement around investigating those. Where there's a conflict of interest, there should be no conflict of interest. If there is an issue, you should be putting it in writing to the relevant personnel, be it a management agent informing the OMC directors in the OMC. Of a potential conflict of working in whatever their services they're providing. If there's a conflict, put it in writing, and don't assume that the OMC knew about the conflict. Put it in writing, and so everybody is clear. Matters which the PSRA will not investigate, and I suppose we get a lot of complaints in that we have to decline because first of all, we don't have a statutory remit. The types we get is complaints by members of an OMC from a tenant or landlord against the OMC or the property service provider acting on their behalf relating to issues including service charges, AGMs, maintenance of common areas. These are matters really for between the property management agent and the OMC directly. Such matters should in the first instance be referred to the directors of the OMC. Where a management agent has been engaged by an OMC, the agent will only take instruction from the designated directors of the OMC. Again, and no management agent can't be taking directions from 11 or 12 members on an OMC. It's just impractical. How accessible are contact details for directors of OMCs? Matters of complaints by tenants, landlords against OMCs who do not fall under the remit of the PSRA. The OMC is a client of the licensee. So there's certain type of complaints we get in that are outside our remit. If you have as a tenant or landlord and you have an issue with the OMC, you should be contacting the OMC directly for them to contact then the management agent relating to it. OMCs are governed by the Multi-Unit Development Act, the MUD Act, and are subject to company law. And any member of an OMC has recourse to the Circuit Court for redress. And just to make you aware of that. Complaints OMC are alleging that they are carrying out property service in their own multi-unit brand without a licence. An OMC is entitled to self-manage, as we said earlier, and are not obliged to appoint a property management agent to manage their multi-unit development on the OMC's behalf. The OMC can pay a consideration to the director or the member of the OMC to self-manage the multi-unit development. However, if a third party is engaged by an OMC, they are required to have a license. So anybody outside of the OMC, third party, is required to be licensed. Advisable to appoint a management agent who has experience in managing public areas in an OMC and procuring services. It is a good idea to have a management agent in place. Please note, PSRA has no remit over the level of fees charged by a property management agent for managing an OMC, nor the fees charged when preparing replies to the requisition on titles, pre-contract inquiries where a unit owner is selling their property. And I know we have a query question on that later. This matter is dealt with in the LOE Part 4, additional services which may be provided by a property management agent or directors, costs of which are agreed in advance of the delivery of the service. Just a bit about, we have, addition to our own act, we have introduced minimum standards. They're reduced back in 2020 around delivery of services and customer service, consumer protection matters. Addresses various issues, but one of the key things we introduced was timeframes. So the LOEs now have timeframes around methods of engagement with property management agents, timeframes for the transfer of monies, maybe from the agent's own client account to the relevant account of the OMC. Unless specified in the LOE, because that's your opportunity to specify your own ground rules and your own timeframes. Minimum standard specifies the timeframe. So unless the LOE specifies a particular timeframe, the minimum standards timeframes outlined in that regulation apply. And conduct and behaviour again is addressed, how an agent behaves in relation to delivering its services. Conflict of interest, I spoke about it before. If there is a conflict or potential conflict, you should be putting it in writing, so everybody is fully aware and can make an informed decision around that. A licensee who is a unit owner in a multi-unit development may become a director in that management body, OMC, and I know we have a query on that as well. So if you are a unit owner, you are entitled to be a director of the OMC. Where a licensee is a unit owner in a development and intends to provide a property service to that development, the licensee should notify the fact in writing to the secretary and all directors of the OMC. Again, potential for conflict of interest there. If you put it in writing, everybody is very clear on the potential for the conflict and either have some input into the decision around that. We have powers of prosecution. It's something we don't like doing, but we have powers to ensure that there is proper regulation of the sector. And we often, under Section 28, will prosecute for unlicensed trading. So we do have powers of prosecution, and we had a successful prosecution actually in relation to a management agent in Dún Laoghaire District Court recently. So we for unlicensed trading. So it's something we actively undertake. I spoke earlier about the complaint case study in relation to an OMC and insurance. I'll quickly go through this. It's just an interesting one, and we'll provide slides afterwards if people want to look at it in more detail. We got a complaint alleging that a property service provider had failed to collect service charges from unit owners, and this has resulted in the non-payment of insurance for the development. On receipt of the assessment of the complaint, the PSRA commenced an investigation and found that the licensed agent failed to ensure that a valid letter of engagement was in place following the expiry of the original LOE. PSRA also found the individual licensed property service provider, along with the property services company, failed to collect service charges from unit owners, which resulted in insufficient funds to pay block insurance premiums for the OMC. It was also found that both the individual and the company failed to inform the OMC that the block insurance was not paid, meaning the development was uninsured for a period of up to 8 months, and the OMC was unaware of this position. Despite these failures, the company continued to receive their property management services fee. So while not delivering on one of the key aspects of their the contracted services, to provide ensure that insurance is in place. They failed to do that, and they failed to inform the OMC of it. PSRA made a finding of improper conduct, and a major sanction, which is one of the most serious sanctions that a licensed agent can receive, was imposed in two parts. Namely, the property service company was ordered to pay the PSRA 50,000 by way of financial penalty, and as well as 2,000 for the cost of investigation. And the individual licensed property service provider was ordered to pay 20,000 to the PSRA by way of financial penalty, as well as 1,000 for the cost of the investigation. I spoke about the compensation fund earlier. It does relate to dishonesty. So we have to, if we get a claim for a compensation fund, we have to investigate it. And where there is claims that there was dishonesty, then the fund will pay out. To date, the PSRA has received 8 claims of compensation fund related to the D licence holders. So 3 claims were made by OMCs, 1 claim was made by the director of an OMC, 3 claims were made by unit owners. A total of 107,581 was paid from the compensation fund in relation to these cases, where the fund granted the payment in relation to that level of dishonesty. We've come to the end in relation to our contact details. Again, the PSRA are available to be contacted in relation to any query that you might have. So you can email us at info@PSR, or look at our website, in particular for that register of licensed agents at psr.ie. There's our contact details by telephone. And if you have a query, we do ask you to contact us, and it's better to deal with something before it becomes a more major issue. Thanks, David. That's my wraparound. Not bad on time either.
Gurvila Mahagut, Maeve, fantastic timing there, actually ahead of time. So fantastic stuff. Really, really detailed presentation, and very grateful to you for the work and background and effort you've put into preparing that material for everyone here on the session. We have, as promised, a Q&A section, and I'll call on Antoinette Gavin to turn on our video and our audio as well, so that Antoinette, you can participate in the Q&A. We'd asked people to send in the questions in advance, and we've collated those and we put them on the slides. We've removed any identifying information, of course, and anonymized the material. So we've about 10 questions, and we'll go through them as best we can before 1:30. So the first question, question 1. My question would be around the management agent, and if there's any responsibility to follow up on fee collection other than the statements sent out annually. So, Antoinette, I might ask you to comment on that question, please.
Yeah, so this should be outlined in the letter of engagement of what the management agent should do. And if it isn't, and there is issues with collecting fees, then the management agent should speak to the directors, and he or she should take the instructions from the directors and have them in writing, or they can amend the letter of engagement to reflect same.
We have produced a couple of years back detailed guidance with our colleagues in Chartered Accountants Ireland. It's there on screen for you, as is the link to where you can get the guidance on our website. It's called Owners Management Companies, a concise guide for directors, and it tries to cover in as concise a fashion as possible the 10 topics listed in the middle of the screen, one of which is finances, cash and debtors. So chapter 5 or section 5 of that guide is finances, cash and debtors. And there's guidance there in relation to potential debt collection policies and how best to go about chasing up annual management fees. We also have on our YouTube channel 28 different webinars, but one in particular I draw your attention to. It's shown in the top left-hand corner. It's called Session 2 of the MUD Act, Session 2 of the training for the sector. It's called Service Charges and Debt Collection, and that gives really detailed guidance from an expert legal advisor about how to go about collecting service charge debt from the point of view of debt collection policy, issuing invoices, the timing of all that as well. So that's one particular webinar that you might find useful on that particular topic, but there's a myriad of different topics and issues covered, as you can see on screen. So hopefully those are of assistance. The next one, question 2, which is a kind of a long one, as are a number of our questions actually. Some of them are multi-part, so we'll do our best to get through them, but it's a long question, but a very pointed issue. Is it acceptable for an AGM to be run webinar style style where OMC members are muted unless permitted to speak, unable to see or communicate with other attendees, and not allowed to ask questions before a vote on increased fees, with the vote proceeding despite members reporting difficulties logging on and participating properly. If you've received our MUD's Matters newsletter, you will have received details of this new information note issued by the Corporate Enforcement Authority. The Corporate Enforcement Authority, as it suggests, as the name suggests, is the state body, the government or the state body under the Department of Enterprise, Trade and Employment that's responsible for dealing with complaints on company law matters. So failing to hold AGMs, failing to submit annual returns, etc. And the Corporate Enforcement Authority happily, as I said, issued this guidance on electronic participation in general meetings. The link to the guidance is there on the website. The overarching rule, if you like, or law is that attendees at the meeting should have a reasonable opportunity to participate. That reasonable opportunity to participate is defined and explained further in the guidance, and we'd recommend that to you and recommend that to everyone involved in OMCs dealing with virtual general meetings, be the AGMs or EGMs. Really, really good guidance, takes you through all the details, and that will answer that questioner's question. The next question, question 3. This is kind of a complex one, and sometimes we're putting them up on screen as we receive them, so we'll have to parse them a little bit and try and drill down into it. The owner of the common area is not transferred to the OMC, is a director of the OMC and also an employee with a PSRA license of the management agent. Is it not a conflict of interest as he takes the majority votes and does what he wants in the estate? So maybe we were looking at this one earlier, and the first thing that jumped out at us was that the common area should be transferred to the OMC about 15 years ago under the Mud Act. So that was the first one. And then I'd throw it over to you, Maeve, on the conflict of interest point.
Yeah, just the question, just I think there's one or two interpretations of it. I'm taking it that the owner is a majority holder of the apartments in the OMC, and maybe incorrectly assuming that, but it looks to me that they may be, and if that's the case, that they have the votes, obviously, to vote on particular issues, whatever the OMC is voting on, and that's legit. There isn't a conflict of interest if they are a majority, if they hold the majority of the votes. That's just democracy, I suppose, working. Just the question isn't absolutely clear. But if there's a conflict of interest on behalf of the owners, there isn't a future, there's nothing really the PSRA can do in relation to that.
I think it's one that maybe, as you mentioned and as I mentioned, that the engagement of a legal advisor, a solicitor, might be useful for that person if they
First of
want
all,
to.
the transfer of the OMC, the common areas should be addressed pretty sharpish.
Very good. Moving on to question 4, which is a multi-part question, so we'll try and break it down. 4.1, are members of an OMC entitled to access the full home registered addresses of all members contained in the member list rather than just apartment addresses, e.g. if they wanted to call an EGM? Well, there is detailed guidance on the topic of the register of members, which is effectively the list of owners of properties in a multi-unit development who are also by definition members of the owner's management company. And again, the Corporate Enforcement Authority 4 years ago now issued a detailed note on the rights of access to the register of members under the Companies Act. So that's the cover page from the guidance and the link to it on the Corporate Enforcement Authority's website. Without getting into fine detail, the register of members contains the name of the owner and the correspondence address that they've provided to the company on the register of members. It may not necessarily be it may not be the home address, or it may be the apartment address, but it is a correspondence address. There are no email addresses, there are no phone numbers on that document. So I'd invite that questioner to maybe drill down into that guidance document, and they'll understand exactly how their access rights work for that document. And while I'm on the topic of, I suppose, access to information, there is a detailed guide from the Data Protection Commission on wider data protection issues for OMCs and MUDs, dealing with interactions between OMCs and members, OMCs and agents, and OMCs and third parties. And the link to that document is on the slide as well, which you'll have later on. So that's question 4.1. Check out the guidance from the Corporate Enforcement Authority. 4.2. In a self-managed development, can a non-owner be a chairperson or director? Well, whether the development is self-managed or not, who can be appointed a director of the company and of the or chairperson of a meeting is defined by reference, first of all, to the Companies Act and also to the Constitution or the memo and articles of the owner's management company. So anyone can be, theoretically, anyone who's not prohibited by the Companies Act can be a director of any company, including an OMC, provided the company constitution doesn't prohibit it. So to turn it around, there could be a provision in the company OMC constitution, memo and arts, to say you must be a member of the company, you must be an owner in the estate to be a director. So you'll need to look at the company constitution.
Sorry, David. And
Yes,
just to add,
thanks.
sorry, just to add to that, that if it's a self-managed development and that non-owner is a chairperson or director, that person cannot provide a property service to the OMC unless they have a license because they're not an owner in that development.
Very good. 4.3, in a self-managed development, can a director of the board provide property services to the OMC without a license? I think Antoinette has just answered that one.
Yeah.
4.4, can members of an OMC be penalised if they allow board member continue providing property services if they're aware that he or she is not licensed? Again, I think asked and answered. 4.5, is it good practice for a board member's personal accountant to oversee the accounts of the OMC? Well, I'd refer you back to the guidance from Chartered Accountants Ireland on auditing, on accounts, on management accounts, etc., etc. There's a lot of good material in that, as is there in the guidance around company law and best practice around that. 4.6, can the board of an OMC refuse to grant a parking permit to an owner member if there's an ongoing dispute between the parties? This is a topic that's probably covered by reference to the head lease, so the contract, the lease in place between the owners, the OMC, and the developer. So parking permits, a contentious issue, and it's often used as a way maybe to collect service charges. So we would invite people to check out the terms and the covenants of their head lease and the house rules related to the estate. So hopefully that questioner has good insights and guidance on that one. Moving on then to question 5, which is around sinking funds. Currently all 5.1, currently all owners service and sinking funds are sent to the operational bank account. Is it acceptable once a year to have a reconciliation of the sinking fund account? Well, under the MUD Act, an OMC is required to set up a separate account. It doesn't necessarily say a separate bank account, but that's the interpretation of the legislation. The sinking fund must be in a separate account. So that's a requirement of the MUD Act. As to reconciliations, look, talk to your property management agent, talk to your accountant around the practices there. But the key issue here is that the sinking fund must be in a separate designated account, and that's the primary requirement there. 5.2, as the age of the apartments in Dublin, Ireland is advancing, the amount of the sinking fund request is now over €1,000 per annum. Will the housing agency be carrying out audits of the management of the sinking fund? I suppose it gives me an opportunity to maybe make the point that the housing agency is not a regulator or a dispute resolution body or a legal advisor in relation to MUDs and OMCs. We're here to provide information and guidance around these topics, and there is a webinar on sinking funds on our YouTube channel, so there's detailed guidance on that topic, and hopefully that will assist that questioner. Question 6 is a big beast, is a behemoth here. It came in by letter, so thank you very much to the questioner for doing that. It's, I think, about 7 different parts to it, so we'll again try and break them down. First one, is it ever permissible for the management agent to chair AGMs of the owner's management company? So Antoinette or Maeve, I might throw that over to you.
Yeah, I think it is. It's not ideal, but it does happen when we do understand there is sometimes there's a deficit there. People can't make it, but so it is possible and permissible for a management agent to chair an AGM or an EGM.
Should the notes of the OMC directors to the annual financial statements containing information concerning the property service agreement for the provision of property services for the information of members? So what we think this is a question about the content of the annual financial statements of the OMC and the notes to those accounts and what should be in them. And I'd refer you back again to the concise guide with Chartered Accountants in Ireland, which explains the difference between audited accounts, unaudited accounts, abridged accounts, unabridged accounts. management accounts, and so on and so forth. So it's ultimately a matter for the judgment and discretion of the directors as to what goes into the notes to the accounts, subject to what's in financial reporting requirements. So we'd invite the questioner maybe to take a look at the relevant chapter in that guidance to cover that particular topic. Number three, I think, is a question for our colleagues in the PSRA here. So paragraph 4.1 of the Form D letter of engagement, the duration of an agreement should not be greater than 3 years as provided for the MUD Act. What's the position concerning extensions of the agreement by means of execution and new agreements? So I think you've covered that, but if you want to comment on it, Maeve, briefly.
Yeah, just the MUD under the MUD Act, the agreement should be no longer than 3 years. But then you should enter into a brand new. If you want to continue the engagement between yourselves and the management agent, just enter a new agreement, a contract again, as we outlined. There is an opportunity to amend any of the provisions that maybe aren't working, or include extra provisions within that contract. So there's no problem renewing the contract with the same management agent, but you are required to put in place a new agreement then once that has expired.
Thanks, Maeve. And question four really is the same kind of topic, so we've
Same.
covered that off. Maeve kindly mentioned the guide that the agency has produced to hiring a property management or engaging a property management if you're changing agent. There it is, and there's the link to it, and Maeve kindly shared it earlier on. There was also mention of insurance and the case study where the property was uninsured for 8 years or 8 months rather, very, very serious situation. We have produced a guide, the first ever dedicated guide to insurance in multi-unit developments. It deals with overinsurance, underinsurance, who's required to insure, all the different jargon. There's a glossary in it. There's a link to it on our website. Next portions of this questioner's questions, which is really, we're not going to read through this in detail. We're getting tight for time. It's really about, the situation where the OMC, the common areas haven't been transferred, the developer is in liquidation, and communication around that particular process. Really, we'd invite that person maybe to contact an expert solicitor in this sector and take detailed legal advice around it, because it sounds like there's a lot of different issues coming up for that particular one. Number 6.6, if you like, disclosure of the execution of the agreement between the agent and the OMC under Section 17 Annual Report of the MUD Act. Again, there's guidance in our document with Chartered Accountants Ireland on what should be in the suggestions around what might be in the Section 17 annual report. So that might be something that questioner might look at as well. Question 7.1, are members of OMCs entitled to obtain copies of any contracts entered into by the OMC and its management agents? So I don't know, maybe you want to have a comment on that one.
Do you want to take that one?
Yeah, I can take that. If a OMC is run correctly, really they should be providing copies of contracts to members of the OMC. So you can request them, but good governance would say that they should be provided if you request them.
Very good. 7.2, are members of OMCs entitled to obtain copies of the audited financial accounts of its management agents? If the management agent is a body corporate, if it's a company incorporated with the CRO, anyone can go onto the CRO website and get copies of its financial statements. That's public information. So whether you're entitled or not, it's public information, so it's there, and you can look it up on the CRO website. So I think this is the second or third last question. Question 8.1, excessive delays in obtaining MUD Act information from management agents resulting in the sale of property stalled for months. MUD Act says such information should be provided within 5 working days upon request. The MUD Act doesn't say that. The guidance issued by the PSRA recently indicated that was good practice. How can this be enforced? How to deal with this situation? So Maeve, do you want to have a quick one on that?
Yeah, just I suppose it's cropping up. It's an issue that we're having to deal with. Really, what we suggest here is that the solicitor contact the management agent and follow up with the management agent. We shouldn't be the first point of call. Like if there's an issue around the details not being provided, within the suggested time frame around 5 days, we would suggest that you get your solicitor to follow up with the management agent. Look, in the event this is excessive and it's stalling the conclusion or of contracts in relation to the sale of property, then I think it's appropriate to contact us. But again, the OMC should be made aware by the person, the owner, that the management agent isn't delivering on this aspect under the contract or the letter of engagement, where it's specified that they will charge a fee for these documents and details. So the first protocol I would suggest is for solicitor to follow up with the management agent, and for the owner to inform the OMC that the management agent isn't delivering on this
Very
before
good.
they come to us with the problem.
Thank you very much, Maeve. 8.2 is really a question in relation to the fire defects remediation scheme, and I've included in the slides, and there it is, the contact details for our colleagues in the remediation section who can deal with that question. And the last question, can OMC directors refuse to answer members' questions directly regarding accounts, spending, quotes, planned works and timelines, by insisting all communications go through the management agent, who then only provide vague replies that matters is being worked on in the background? But I suppose the primary forum for any member of an owner's management company to question the directors is at the annual general meeting. So that would be one route to get direct contact with the directors. But I don't know, Maeve or Antoinette, if you want to reflect on that particular question.
If a member asks a director a question around the development, really directors should be responding to them, because they are a member of that development. They're all part of the company, and they've asked questions, and governance, correct governance would say you should be responding. And then it stops any issues or complaints or whatever if people know what's happening.
Very good. Thank you,
And I
Antoinette.
suppose what leads on to that too is that we would actively encourage owners in an OMC to attend these AGMs and EGMs. That's the only place that they're going to get questions answered or the information they need of what's going on in their complex. So certainly attending an AGM or an EGM should be actively encouraged.
Very good. Thank you, Maeve. That concludes our Q&A session, and it's coming to wrap up our webinar this afternoon. Before I do that, just to give you a quick reminder of our next webinar on the 26th of June on the topic of improving waste segregation in apartments. Remember to sign up for our MUDS Matter newsletter, where you'll get details of all future events and activities. I would like to say thank you very much indeed to Maeve, Antoinette, and to all their colleagues for the work they put into having this session on today. There's a lot of background activity goes into getting this successfully delivered on time. So thank you very much indeed, Maeve and Antoinette, and all the colleagues in the background. Thank you very much for everyone for attending today. Tásul agam go manshiv tanyav as agus sultas on webinar agus go maishiv arashar ishlin ag amelas ataiki. So thank you very much indeed to everybody, and we wish you a pleasant afternoon. Slán.
Thanks, everybody. Thanks.
Thanks. Bye.